Never been heard. I asked to have you, Your Honor, I asked you to recuse yourself only for the purpose of the YouTube. That was the only reason I did it, and it was refused, but.
All right, and that was denied by by another judge, correct?
Yes, because I couldn't prove it under civil procedure. However, I'm requesting and objecting right now because my client has a presumption of innocence, which has been discouraged by showing him in prison clothes in front of a live audience of over maybe 1 million people.
Okay, please don't talk over me.
I'm not going to talk over you, Judge.
He's still talking over me.
Well, you're cutting me off.
When I talk, you stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Okay, don't come then and see what happens.
So we are sincerely, and she can tell you, but I just felt the need because I am the president of that organization and which Ms. Shabazz is part of. That is not how we are going to treat anybody, and nothing about courtroom 234.
Yes. No, the deputies wanted it changed for security issues. And are you Mr. Ruiz? All right, we're here on a motion to unseal documents, motions, and orders that were sealed. State, have you had a chance to review the defense's motion? All right. So defense is asking for.
First,
Sure.
make an objection to the use of the YouTube during this hearing.
All right, that's denied.
Your Honor, may I give my reason on the record?
All right, do you have an order? Do you have a motion?
I have a motion and an order.
All right, do you have a motion that's been filed? All right, so State, do you have any objection to an oral motion?
It's been heard. I believe there.
It hasn't been
some
heard. The
kind of-
motion to recuse. I'm sorry.
This issue has been heard. I believe there was a written motion previously, but it was ruled on. I don't have an objection to her re-urging her motion.
All right, you can re-urge your motion.
And Your Honor, it has never been heard. I asked to have you, Your Honor, I asked you to recuse yourself only for the purpose of the YouTube. That was the only reason I did it, and it was refused, but.
All right, and that was denied by by another judge, correct?
Yes, because I couldn't prove it under civil procedure. However, I'm requesting and objecting right now because my client has a presumption of innocence, which has been discouraged by showing him in prison clothes in front of a live audience of over maybe 1 million people. I don't know, but his presumption of innocence has been damaged because of this YouTube experience.
All right, that's denied.
Would my client sit in the jury box so he wouldn't be in front of the YouTube?
I mean, we're here on a motion, so he's here, or either he can sit at the table. He can either sit at the council table or he can stand here.
He can sit at the council table.
All right, so y'all go back and sit at council table. All right, so defense, who has filed motions under seal?
Don't know, Your Honor. I only have access to the public computer that the rest of the public has access to. It shows as sealed, 2 sealed documents with different numbers attached to them on October 31st. It includes also 2 sealed motions. Now, it's my understanding that my co-counsel, Ms. Efron, filed motions for payments for mitigation experts.
Microphone on,
I'm sorry.
there's a little bit of distraction. I didn't hear the name, Ms. Who?
Does that work, Ms. Carrero? You have to. Oh, when I'm talking, okay.
I didn't hear the name of the person you said co-counsel.
My co-counsel is. Oh, it just stayed on, okay. My co-counsel is Lorraine Efron, and she filed motions, I know, for fees for the various people that are attached to our case. And
So,
reasonably sure that
just
was
one
October
second.
31st.
Just one second. So let's start with this first one you're talking about. October 1st, 2023. Is that a motion that the defense filed that you want unsealed?
Not necessarily when I found out it is a defense. Unfortunately, Your Honor, what we received on the computer, and I made copies for myself, not for anybody else. But when I received on the computer, mentions a motion and order filed. I don't know who files it. We don't always know. Miss Mitchell has been helpful as much as she can be, but I'm not sure. The reason for this particular motion to open unseal was because of when the plea was entered.
No. Let me stop you. This is my question. So October 31st, 2023, are you asking that that motion, whatever it be, even if it's a motion that was filed by the defense for your expert or whatever, you want it unsealed?
Yes, Your Honor.
State, do you have any objection to unsealing a motion that was filed on October 31st?
No.
And to the clerk, are you able to look and see who filed that motion? All right. November 1st, 2023. State, is that your motion?
Sealed motion order? I don't know what it is.
No, that was not our motion.
Okay. November 15th, 2023. State, is that your motion?
No, Your Honor.
November 16th, 2023. Is that your motion?
No, Your Honor.
November 22nd, 2023. State, is that your motion? All right. And what other dates on here? Because you mentioned any other dates unknown to movement.
Well, I have at my wherefore paragraph, any other motions and orders in the interest of justice that are under seal. The reason for this is because during the plea of Katrina Mendoza, the co-defendant, on August 7th, after she entered her plea, you turned off the YouTube and you had a private conference with the defense counsel and state, and there's no record of it. And so I'm wondering, is there an order there somewhere? I don't know. I don't know what happened in that conference. YouTube was turned on again when your conference was over. And I don't know what went on with it.
Well, if people would have been in courtroom that day, they probably would have heard what went on. But you're asking for any other dates unknown to movement. You are not asking for orders for the any other dates, or are you?
Unseal any and all documents, motions, and orders in the interest of justice.
All right. So what I will do, state, if you have no objections, I will grant the motion to unseal the motions that she's asking to be unsealed. And I'll do an in-camera inspection because I don't know what these motions were sealed as to. I don't know if it's something that everyone is supposed to see or not, because I don't know what it is.
Your Honor, I just pulled up the co-defendant's cause number 2022 CR 4248B. And it looks like a lot of the dates she listed do correspond to what appears to be sealed motions in that case. So perhaps she's referring to, I believe the defense counsel is Todd McRae. I don't know if he needs to be here.
Yes, he would need to be here. If these are motions that you're asking to be unsealed and they're in the co-defendant's case and it's motions that that defense attorney has filed on behalf of their client, you may not be entitled to have those motions unsealed.
Is that a ruling, Your Honor, or are we going to have another hearing on this?
Oh, we're going to have a hearing and Mr. McRae will be here. And Mr. McRae may have an objection to the unsealing of motions that were filed in his case, perhaps by him, perhaps by the state. So this is the court's ruling with regards to the October 31st, 2023, November 1st, 2023, November 15th, 2023, November 16th, 2023, and November 22nd, 2023, and any other dates unknown to the movement. Court is rescinding any rulings that were made previously because the court assumed that these were documents that were filed in your client's cause number and not the co-defendant's cause number. So what will end up happening is the attorney in that case will be here, and that attorney can raise objections if he so chooses to having documents that he may have filed on behalf of his client and their cause number.
What I was quoting you was all their cause. It's the same cause number, it's just an A or B difference.
No, but here's the thing. if that defense attorney, Mr. McCray, filed sealed motions for his client, it may be experts for his clients, and he may not want those unsealed. And the question becomes whether or not you are allowed to unseal or have unsealed sealed motions that he has filed that, for example, if he hired an expert for his client and he does not want the state or you to know what the findings are of his experts, he has the right to keep that sealed. So he needs to be here to see if he has any objection. And I made my ruling previously thinking that these dates were dates that were under your cause number, but the state is telling me that these are dates under the co-defendant's cause numbers and not your own.
That's true.
Oh, well, then Mr. McCray needs to be here.
Probably for the next one as well. I'm asking for a copy of the PSI for Katrina Mendoza.
No, with regards to the PSI, Mr. McCray has no ability to object to your seeing the co-defendant's PSI. That is an order that you need to have heard to see if probation will allow you to view that.
I have to file another motion in order on that?
Yes.
Thank you. The other thing I'm asking for is a transcript of the witnesses that the state intends to call at time of trial.
What transcript?
Transcripts of the statements. The child who was a sister of our decedent Mercedes Lozoya is listed as a witness.
Well,
We'd like her a transcript of that, as well as anybody else they're going to call as a witness.
when you say transcript, was there testimony or you're talking about them speaking to the police?
Voluntary statements.
All right. If they have statements, it should be in your discovery.
It's not this, did not get a copy at all of young Jordan's. She was 6 years old at the time. I believe she's about 8 now.
It's a forensic interview, Your Honor. The disc has been in the file. The state has given defense counsel, actually, I brought the file down to court for multiple days for defense counsel to view with a separate clean computer.
Yes.
We've made it accessible.
But yes, technically they did, Your Honor, along with 3,000 plus other evidence of discovery. Personally, I put in close to $200 hours out of court, just me. Lorraine Efron has a whole nother bunch of hours. Out of that, I would like to request a transcript of Jordan's, rather than just her testimony, a transcript of it. Voluntary statement.
All right. So let me ask you this. This statement, was this statement made, this alleged statement, was it made in English?
It's made in English. Yes.
All right. Then you all need to view it. The state has given you opportunity to view it. I know that in this court, and if I'm wrong, correct me. I think during the holiday, I want to say November, Thanksgiving, I had the deputies have your client brought over and for you all to watch the video. So I'm not ordering them to transcribe a video. You need to watch it with your client. And the court has made the courtroom accessible for you all to do that. I'm not going to order them to have somebody transcribe a video that is in English.
Your Honor, excuse me, but we were never presented in court, and I thank you for the time you did give us, but for over 3,000 bits of discovery, which is it's 2 inches thick. When we ultimately file our 3914 motion, when we ultimately file, it's about 2 inches thick. We did get to see videos. We got to see certain statements. We never got to see Jordan's. We have to go to the office to see that. I'm requesting an actual transcript of her voluntary
All right,
statement.
that's going to be denied for them to do a transcript. Deputy Mejia, is he able to come over here Wednesday to view a video? They will bring him over Wednesday to view a video.
Of Jordan.
There's multiple. I can bring them all over.
All right.
In particular, that one.
She just wants Jordan's. Is that correct?
That's fine.
No.
Get an opportunity to view the statements.
Now, my question is, do you just want them to bring Jordan's statement over?
That's fine. Yes, Your Honor.
All right. So she just wants Jordan. And Mr. Ruiz will bring you back Wednesday and you can see the video.
Your Honor, I have 2 other things that are not, one of them is from an order that Judge Harrell granted back on August 28th. It was about the medical examiner. She was subpoenaed pursuant to that order to be here on a given date, and she didn't show up. She had some other reason. She sent instead a pile about an inch thick of papers that weren't sealed, not sealed, but were not attached with a rubber band. And when I was reviewing them, I realized there was no certification of the records custodian as to the validity of those documents. So I'm going to do myself, with your permission, write a letter and ask for this custodian to send us another packet that has been notarized. If you're all right with that.
Oh, I'm not in charge of that at all.
Your Honor, I do have a brief response to that, just because Dr. Molina is, she's very responsible and she does stay on top of her things. She was in contact with me that day, and she had prior obligations, but she did send her assistant with all of the documentation that they had to. It was just a subpoena to bring documentation, Your Honor.
Mhm.
They brought the documentation, and then when we were conferring just in court, that it was acknowledged that really they just need Dr. Molina for a 705 at trial. So that's why she did not appear.
But we tried to do it beforehand in the interest of economy of the court. Even still, the fact that the documents were presented loose with no certification by the records custodian, how can we possibly use those records? I'm just asking that we get another copy certified by the records custodian before we go to trial.
All right, I'm not going to order that. If you all want something, you just pick up the phone, call the ME. You said you've already subpoenaed her in the records, then that subpoena is still in place.
Thank you. And one other thing, Ronnie, you referred, because I wasn't in this case until a year after it began, and I would like to get a copy of judge's notes in the file with your permission.
Sure, here's the docket sheet. The notes are on there. And this
It's
record
not
is
the
public.
same as, excuse me, Your Honor, I don't believe it's the same as the actual notes that are in the file.
This is the entire file. This is this file here. This is the court's file. I don't have anything else.
You
If
didn't
it's
write
not in this
anything?
file, it doesn't exist.
There's nothing written in the file, in other words. It's all on that.
It's the docket sheet. I write everything down on the docket sheet, and any orders or motions or any letters that have been received from the jail by your client, it's in here. This is the court's file.
So if I can get a copy of that, you're talking about.
Oh,
the
we're
docket
not.
sheet.
Here's the thing. We're not going to have the copy machine at back and use the copy machine for you to make copies on this. You're more than welcome to write down whatever you want to write down from it. You're more than welcome to do that.
Can I send somebody to do that? Or can I send a records copier company to come and copy that?
Here's the issue with that. This is a legal document. This document, this file, the custodian of this file, technically and legally, is the district clerk's office. So you would have to clear that with the district clerk office if they would let some outside party come in, take this file apart and get copies of it.
But in there is the year before I was appointed. It has all the comments that the court made. Is that correct?
What is in here is what is in here.
February 7th was the arrest date. It's the date of Mercedes' death. I was appointed and actually activated in April 2nd. There's that whole year took place. Lorraine was replaced by Debbie Burke, who was hired and then withdrew. Mrs. Burke was involved for 9 months. I don't know what happened during that time. I don't know what orders the court made. I don't want to run afoul of anything.
It is on the docket sheet, and any motions that were filed that are not under seal are in this file. And any orders that were heard are in this file. If it's not in this file, that means that it's not in this file and no order was heard.
Okay, thank you. And can I have the same access to Katrina Mendoza's file?
I'm not in charge.
Technically, they're all.
The,
technically for public
here's the
records.
thing, and I want people to hear me clearly because maybe I'm not communicating properly. These files are the court's files. And when I say court's file, I don't mean they're Stephanie Boyd's files. I mean, these are the files to the 187 District Court. The custodian over these files are the district clerk. If anybody wants some inside party to come in to copy this file, you need to speak to the district clerk about it and see whether or not they are allowed to come in to make a copy of the file. I am not the custodian of the records of the file. Do I write things in the file on the docket sheet? Yes, I do, but I'm not the custodian of records. So if you want to bring some third party in to make a copy of John Doe's file, Amy Doe's file, whoever it may be, that needs to be cleared with the district clerk's office because they are the custodian of records of these files. I am not.
Okay.
And what I can tell you is the normal practice in this court, if there is a hearing held, if I give a ruling on something, I write it on the docket sheet. That's where we are. State?
Your Honor, in violation of condition number 2, on or about the first day of June 2021, in Bexar County, Texas, the defendant, Alfonso Christopher Diaz, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
And Your Honor, we'll waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Diaz, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court would find violation of condition number 2 true. Is there an agreement?
Your Honor, we do have a agreed recommendation to enter an adjudication of guilt and to sentence Mr. Diaz to 2 years in the Texas Department of Corrections.
Is that the agreement?
Your Honor, that is the agreement.
Mr. Diaz, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court will follow your agreement. Yes.
Excuse me, Your Honor, we would ask that Mr. Diaz be credited for all the time he has served in this case, which is quite a bit. I think it's 271 days.
All right. So here's my question. What has he done on probation?
Judge, he hadn't done much. To the court, I'm sure he's an absconder. Mr. Diaz felt he has mental health, serious mental health needs, resulting from severe head injuries. He felt he wasn't able to get the treatment he needed for it here in Bexar County.
Well, I mean, not really, because counsel, I see that I've heard a previous motion to revoke for him. Now, mind you, this is from 2017. And I know I wasn't on the bench on 2017, so I don't know what another judge did. But I know in this court, I always ask anybody, is there anything that they need that I haven't given them? Is there anything that probation is not doing that they feel that they haven't done? So if he didn't have mental health issues addressed, it's because he didn't ask for it. But we were here on April 28th for a violation of 5 and 15F. And I denied those motions and I said he's enrolled in the BIPP within 10 days of release from custody. And he was allowed to work and we were asking, and I put in GPS. So has he done anything since he's been on probation?
No, Your Honor, he did not complete the CIPP. I believe he started the outpatient program, however, he was discharged unsuccessfully. No, we have not received any UAs from him. There has not been any payments for any type of dues.
So he has done nothing. What have you done since you're on probation? Would you like to address the court?
Yes.
All right, I'm going to raise your right hand. The state is going to have a chance to question you. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Diaz,
All right, what have you done?
I was constantly going, I did sign up for the BIP program, but they wouldn't let me go without a negative COVID test. I did test positive for COVID and did again the following month. And I did do all of the outpatient program, but I didn't submit a drug test. That's why I was discharged. No, as far as the ankle monitor, they wouldn't take it off of me because they wanted me to pay $200, but you waived the fees and they just wouldn't have it. Me and my probation officer were supposed to talk to you about that. And that never happened.
So basically you have done nothing. Like the easiest thing to do is take a UA. You did not do that. Did you ever take a UA?
No,
All right. So that's something that's easy to do. Am I wrong in that assumption?
you know,
All right. Did you complete the BIPP course?
no, I was never allowed in. I have a proof email. You got a letter for it, an email from the people who do it.
So you're telling me since 2022, you have never been COVID-free to do a COVID exam. And actually, there's a motion to revoke that was issued for you July 20th, 2020. And I granted a BF and issued a judge's warrant because you didn't show up. And I'm sorry, it's April 28, 2021. You're telling me that since April 28, 2021, you never tested negative for COVID to start the BIPP course. Is that what you're telling me?
Judge, I have to say, I've never seen an MPR from 2021. The latest I've gotten is from 1920.
No, he didn't. Here it is right here. I think you were not the attorney at that time.
I believe you, Judge. I'm just
Yes.
saying, in my efforts to get all of the motions to adjudicate and revoke, up until this morning, the latest one I had was from 2018. After being assured I'd gotten everything, finally this morning, your clerk handed me one dated from 2020, said, sure me that was the last one. I have not seen them. 2020, the one I have in front of me is the last one I've gotten, and I just got it
Do
today.
you want that, counsel? Do you want more time? Because there's one from February 25th, 2019. And on that motion to revoke, he was not revoked and he was told to do certain things. And from that, and then there's a violation report from 2017, which I didn't consider because I was not the judge at that time.
Judge, I'm not sure it's necessary that I see them. What I do want to disagree with, if I may, is
Mhm.
that your conclusion that he's done nothing. He wasn't able to complete the BIP program because of the COVID problem.
All right, I hear what you're saying, counsel, but you just told me that he absconded.
I just told you that what I intended to tell you was he believed he couldn't get treatment he needed as a result of the serious head injury that he has here in Barrett County. I know that's likely inaccurate, but that's what he believed. Believing that, he elected to go to Massachusetts, where he did get help for that in a number of respects. He obtained a job, which he still has with Walmart for, I suppose it's a union Walmart, for $18 an hour as a stalker. He has gotten counseling up
All right,
there.
but we're in the middle of him testifying. So does anybody want to ask him some questions? Because before me, what I have right now is he's done nothing.
I'll ask a question.
Sure.
Mr. Diaz, where have you been living while you've been not reporting?
For the last 3 months in Massachusetts and North Adams.
What brought you to Massachusetts?
To seek help because it's a Commonwealth state, and I was immediately getting help for mental, from my PTSD, and also I've been getting memory issues, so I decided to seek help for my for a neurologist.
So, but that was 3 months. So where were you before that time?
I was here, I was living in my apartment, I wasn't leaving. I had severe PTSD and severe anxiety, so I wasn't leaving home.
Well, What caused your PTSD?
I was shot at when I was 14, and when I was arrested for the last MTR, I was arrested because I called the police. I was shot at again. And when I was 17 years old here in Bear County, I was beat up while I was here before 17-year-olds were kept away from the general population.
Okay, have you had any contact with the victim in this case, Molly?
No, not so. No.
Do you have a new relationship?
She's the mother of my other two children, but it's purely civil.
And how old are your children?
My other two, 12 and 11.
So you were in Bear County. Did you have a phone?
No, I didn't. No.
Did you have a job?
I had lost my job due to me staying inside it too.
Due to what?
Due to me staying inside, it was agoraphobia. I was afraid of going outside for any reason at all.
So this is what I don't understand. One, these are some questions I have. The first one being, did he have permission to go to Massachusetts?
I don't see anything in the system, anything such.
So we have him going to another state without permission. Two, there's treatment for PTSD here. If it would have been asked for, I would have been ordered. I would have ordered it, and it's not here.
Yeah.
So that's a problem. So what I'm looking at is someone who has behaved as though they're not on probation. And now they're coming to me with excuses as to why I should give them a minimum. And he's had a motion to revoke in 2018. March 2nd, 2018, according to the docket sheet. Then he had another one in November 6th, 2018. And let's say that, I don't know, that judge was like, I'm not listening to you about what you need. I'm not saying that's true, but let's just assume that's true. He came back here July 20th, 2020. A warrant was issued for his arrest. Didn't see him back till April 28, 2021 to address the same allegations that were in the previous motions. And what did I do? I denied it, told him to roll and bip. And he's up here working at a grocery store at Walmart. Well, working at Walmart, I don't know if it's Super Walmart or not. Did you give them a COVID negative test?
No.
All right. So he is trying to tell me, and if this is not what you're telling me, let me know. It appears to me that you're trying to tell the court that you could not prepare or get a negative COVID test since April 28, 2021. And that's why you can't enroll in BIP. So are you telling me that you've had a positive COVID test since 2021?
No.
So he didn't do BIP. He hasn't reported. He left this, not just the county, he left the state without permission. And he's saying he has, PTSD and he can't leave his house, but he sure left his house to go to Massachusetts.
I also left my apartment because there was construction and we got locked in. They lifted the building while we were still in it. So I had no choice but to leave that apartment and I had nowhere else to live.
Yeah, but I mean, you left with
no-
all of your mental health issues that you're telling me that I don't have any documentation of. You left not only your apartment, but you left and went to an entire different state.
Yes.
And I'm not a psychologist or a psychiatrist, but I will tell you in undergrad, I took enough psychology courses where I could have majored in it, but I just chose not to because that wasn't a field I wanted to go in. So you're telling me you can't leave your house because of a mental health issue, but all of a sudden, not only do you leave your apartment, which I understand they closed it down, but you're able to get to another state. And how did you get to that other state? Did you take the bus? Did you take the plane?
Drive.
All right. So you drive to an entirely different state. And I'm sure from here to Massachusetts, there is no car that will take you there without stopping at a gas station to fill up. How many times did you stop at a gas station to fill up?
I'm not exactly too sure every 300 miles, but I'm not the one who was getting out.
All right. So you drove there with someone else?
Yes, my wife. My kid.
All right. So he's driving around with his children. So I can tell you right now, I'm not following this agreement because you have done nothing. And to receive the minimum for doing nothing would not be fair. It wouldn't be fair to you to teach you a lesson. It would not be justice. I understand that sometimes people have built a new life for themselves and they want to forget about the past and act as though that never existed, but it did exist. And you have done nothing. So I'm not giving him 2 years.
All right, Your Honor. Given that the case, I've already canceled the witness I was going to testify this morning.
Oh, no, he's already pled true. I'm going to sentence you to 3 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Molly, Mollie Alvarez. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
You did, Your Honor, under the impression that his sentence is going to be 2 years.
Well, no, because when I asked him, I said, do you understand by pleading true to violation of condition number 2, the court could sentence you up to 10 years in prison and up to a $10,000 fine? And he said, yes. So because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Your Honor.
You're welcome. Carlos Salazar.
Discovery on a case that's not gonna go.
Let me choose my words. I wanted discovery on the case that was scheduled for a preliminary examination at
It's
12
not-
o'clock today.
That's
Well,
not
what-
going,
Well, we don't know if it'll go, because what if the complainant just so happens to walk in? Rather than wait in last hour and we keep on doing this,
it's
if it's
told
a
you all- Okay, please don't talk over me.
I'm not gonna talk over you, Judge.
He's still talking over me.
Well, you're cutting me off.
When I talk, you stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Okay, don't come then and see what happens.
Okay, so do you want Attorney Davenport, who is the attorney on this case? Do you want to speak to him? Because if you're
I
asking me,
thought- Why are you even talking to me if you're not on this case? I don't even want to talk to you then.
well, you asked a question about me, Judge, so I
I
started
don't think
speaking.
you're talking to me if you're not involved in this case.
Well, I am involved. I'm co-counsel on this case, Judge, but just to be,
I want you to come down here at 12 o'clock today,
I won't be coming, but here's Attorney Davenport,
and I'll hold you in contempt of court.
and I'll go ahead and file a grievance.
Do it.
I will.
I don't appreciate any yelling. I feel like it's unprofessional. I feel like she was trying to express the fact that this.
And I asked her not to talk over me, Mr. Davenport. Just like you stopped when I started talking, I expect the same from her.
Just as this happens in other cases, we expect discovery in a timely fashion so we can represent our clients in the best way possible. So as these cases become moot points of discovery, we would like to be able to have a situation where if the complaining witness does show up, we don't have to wait till the last minute. We can either hold the exam or not. We started off asking for discovery in court. We were told we have to submit a discovery order. We started submitting discovery orders. After we submitted discovery orders, we were told we have to keep in communication to remind prosecutors that we have to get our discovery as they're obligated to provide us with. After that, you told us if we were in communication, then we should file motions to compel. We keep trying to do and be proactive. And we're trying to explain this problem right now, but there's no reason.
Mr. Davenport, if the witness was to show up, there's no way I would make you go forward on the case that you just received discovery on today. Period. Now, let me talk about what I don't appreciate. I don't appreciate being talked over. I don't appreciate when I'm trying to make something clear. Ms. Davenport indicates that she didn't understand. I told her to come down here. She told me what she's not going to do. I ordered her to do so. So understand that grievance process works both ways. I can file a grievance as well.
And so in this situation where she's trying to get the case dismissed before 12 o'clock because we wouldn't be holding it whether the complaining witness shows up or not, and we're trying to be efficient with our resources.
I'm not inclined to that. I'm not inclined to grant a dismissal when discovery was given to you, although it was not given to you timely. I'm not inclined to dismiss based on that.
What will be the future? What will be the remedy for future reference?
What future reference? What are you talking about?
So in any other case, in a situation where we submit a discovery order, keep in contact with the prosecutor, submit a motion to compel, and the
I take
discovery
case by case basis, sir. I can't tell you what I'm gonna do in the future.
Oh,
I don't
okay.
know how to comply.
I mean, so we just have to keep.
You're not gonna comply anyway, Ms. Davenport.
I'm sorry, Judge, I didn't hear you.
You told me you're not gonna comply with the court's order. I ordered you to be here at 12 o'clock. You told me you're not doing it.
Judge, I can't come down there at 12 o'clock today, but when you see me on another hearing, or if you want me to come down on a different time, then we can definitely discuss it. In fact, I know that is this recorded? Because if this is recorded, then we both can use it in our grievance. But Judge, you asked me a question. I started answering. You cut me off and then you said, when you start talking, I stop. I'm not a child. I'm not a puppet. I don't disrespect you, and I expect to be respected as well.
I expect you to respect this court.
I do respect this court, which is why when you ask a question, Judge, I stepped in to answer your questions.
I
don't like to talk over people either, Judge. It's just that when you ask me a question and then I'm answering it, when you're cutting me off, how do I know if I'm answering your question? When am I supposed to stop or not? If you want to speak, then I will be quiet so that you can speak. And then when you ask me a question, I'll answer your question. Oh, I'm sorry. You want to speak to Attorney Davenport?
Ultimately, Judge, in this situation, which was a similar situation as last week, and I understand it's unpredictable and we can't really determine what you'll do based off past action. But last week, when the complaining witness didn't show up and the discovery issue was moot on a different issue, I appeared in court physically. Now, that wasn't a requirement for the prosecution as they came in on Zoom, and I have no problem with that because it's an efficient use of resources. However, I don't agree that it's an efficient use of everybody's resources if we're not going to hold this exam to have us continue to come show up in person. We're doing all this back work trying to make sure we're prepared. So we prefer to appear on Zoom.
I don't have an issue with that.
Okay, thank you.
The prosecution is indicating that the witness is not going to appear.
Very well, Judge. Would you like us to appear at noon?
That's what time the exam is scheduled.
That's true.
So you don't want you to address discovery issues in advance no more?
Won't be able to tell. I gotta wait for the next case. Okay, so we will appear back on Zoom at noon for the dismissal. And I'll see you then, Judge. Is there any other issues you'd like to take care of?
No.
Okay, we'll be back. Thank you.
All right. This is in the matter of Justina Shabazz Davenport.
Manager,
Yes.
good morning to you and your staff, Lovely Yellow, D5026 on behalf of Justina Shabazz Davenport, who is to my left. Definitive Davenport. If I may.
Yes.
So Judge, I do understand that there was some conduct that happened in this courtroom yesterday by way of Zoom technology. I had the opportunity to view the YouTube recording. And on behalf of the Wayne County Criminal Defense Bar Association, of which Ms. Shabazz is a part of, let me extend my apologies for the behavior that was witnessed yesterday. And thank you for the grace, Judge, of letting us come forward to try to make it just a little bit better or a little bit less while not forgiving the conduct. I've had the opportunity to speak with Ms. Shabazz and several other attorneys in trying to resolve this issue, and one of them being Mr. Todd Perkins. I take no pleasure in standing here, Judge. And I think I've explained to Ms. Shabazz the error in what happened in the way things happen. So if there's ever an issue that you might have with any judge or any person, you can always go and try to talk it out, as we're all human beings, right? We're just human. That's all we are. And understanding Ms. Shabazz is a younger attorney, and we are learning. But I did explain and say this is one of the reasons why they do not want us to use Zoom technology. That is going to be a poster child for why Zoom technology should not be allowed in the courtroom. I had to go testify in front of the Supreme Court or give comments on using Zoom technology. Sincerely, Judge, sincerely, I really do apologize, because this is not, for me to come down here from Ann Arbor, where I was in court, this is how important this court is to me. This is not how we treat this court. I understand we can have opposite, we may not agree on anything. We don't have to agree, right? But we're not going to be disagreeable just to be disagreeable. So we are sincerely, and she can tell you, but I just felt the need, because I am the president of that organization, and which Ms. Shabazz is part of. That is not how we are going to treat anybody, and nothing about courtroom 234. Is this 234? 234 gives anyone the right. I understand being frustrated, and she's a mother, a lot of things going on, I'm sure, right? But she has been counseled. She will continue to be counseled, because we're really not happy. But thank you for the grace, Judge, and I will let Ms. Shabazz speak to this court. And all I can say is, sincerely, I am sorry. Because as I explained to Ms. Shabazz, yesterday, you got a dismissal. You wanted a dismissal on something dealing with discovery. That would not have been the proper remedy. So let's say we're somewhere like in Novi or Garden City or Brooks Point, right? What would have happened if that was an issue? We're gonna adjourn this preliminary exam and put a witness detainer out. We are client focused and not ourselves focused. It's about the client. And I'm sure Mr. Shabazz understands that at this time. And I will let her talk to you, Judge.
Mr. Shabazz.
Thank you. Let us know about your apology. Thank you for it.
I can really understand what you're saying, Mr. Shabazz.
Pull the bands down a little bit.
Can you hear me good? Can you hear me?
Very.
You want to blow my nose? Can you hear me good?
Yes.
Just want to offer an apology to the court for any disrespect that the court may have received, especially yourself as a judge. I meant no disrespect, and so I do want to offer an apology.
So let me say this. In my 17 years on the bench, I've never been disrespected like that before, ever. Nor have I ever witnessed any disrespect like that coming from an attorney. I see stuff like that from the defendant time and time and time. but never from an attorney. I expect more from an attorney. The only reason that this court didn't hold you in contempt of court at that point in time, because you appeared before this court on many occasions. I don't think you've ever had an issue. You may have had disagreements, but you've never had an issue to rise to that level. We're human, like Ms. Diallo says, and we have bad days, we have good days. Some days are worse than others. That doesn't excuse your conduct. I have every right to hold you in contempt of court. And if it was not for Ms. Diallo, you would be marching back to the jail, Wayne County Jail right now for 3 days. The court would be forced to hold you in contempt of court and to report you to the State Bar of Michigan. I don't necessarily like to do that to young attorneys, particularly young Black attorneys. I like to give some deference to us because I've been where you are, but never would I ever phantom to behave in the manner that you did. It's very disappointing, it's insulting, it was embarrassing. The court is willing to give you a pass on this time. If this ever happens again, Ms. Diallo's not going to say, and I have the utmost respect for Ms. Diallo, for Mr. Perkins, for Mr. Clemens, for Mr. Pope, Bobby Silver, Otis Culpepper, Cornelius Pitts, and other attorneys with way lower P numbers than you have. We've been around a long time and know the proper respect that you should show this court and any court. Your behavior was inexcusable. The more I thought about it, the angrier I got. So I encourage you to follow the lead of Ms. Diallo, who's a very fine attorney, well respected. You're going to get there one day, but you're not going to get there if you continue to behave like you did. This court is not going to hold you in contempt of court. Although I find their behavior was contemptuous. I'm not going to do that this time. If it happens, if you make a mistake about it, nobody's going to say it.
Judge, and once again, thank you for the grace that you have shown. Sometimes I don't think we understand. Like you said, sometimes we have good days, sometimes we have bad days, right? And I know I'm extra. You know I know I'm extra, right? But I
always respect.
Right, I mean, something like that, and we get frustrated at times. I understand, but Ms. Shabazz really is apologetic, and I'm going to continue to mentor in hopes that, and it's not hope, she'll get there, but it's just as we grow, these are growing pains, and I would have to chalk it up to being a new mother and all that other stuff. There are a lot of things that go on, but thank you. And as you see, we take this very seriously,
I
right?
appreciate you, Ms. Diallo.
Extremely seriously. Because I don't feel good about this right now. I feel a certain kind of way.
I didn't feel good about it either. And when you first reached out to me, first thing I uttered to you was talking down to me because I was going to hold her in contempt of court. Because I cannot let that kind of behavior slide in any form or fashion from anyone.
Thank you.
Thank you.
Are we concluded, Judge?
Yes.
Thank you. All right.
Judge, I'm sorry. Are we gonna address that one issue with that case or no?
It's with the case Monday.
For Monday?
Yes.
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 Come on back, Ms. Justina. What's going on Monday?
A case that was originally slated for my docket has to go to another docket. It is set for exam.
Okay, I'm sorry. Could you say that again, Judge?
An exam scheduled for Monday with Ms. Shabazz.
Right.
Ended up on my docket, but it has to go to another docket because of the criteria.
Oh, that's fine.
It is scheduled for exam.
Okay, and she'll be ready. If that's what Ms. Dre wants,
No, we're not
right?
gonna do the exam
On
on
Monday?
Monday. We're gonna put it in another.
Okay. Okay, so she's just getting, posing herself. Hey, Shelley Drain, how are you?
Oh, good. How are you? Good to see you.
So Judge, I'll just stand there. She's getting herself together with that. It's
We'll just do it on Monday. We'll just assign,
Yeah.
find out where it's going.
on Monday. Okay, that's fine. Judge.
Just so she knows, so that she's not preparing all weekend for the exam, it's not.
Okay, thank you, Judge.
Thanks, thank you. Can I see you for the?
You can. You came in, which, I'm sorry, look.
Thank you, Judge.